It's May 17, 2012. This is Justice Done Dirt Cheap. Just going to share some thoughts with you. I filed for leave to appeal a decision regarding a file number FC45.11. And the reason why I filed leave to appeal is because I believe the judge made an error in coming to that decision. I'm just going to share some information about that so you can consider it. Now, a judge is supposed to consider all the facts, evidence, argument, the applicable case law, as in common law, any applicable statutes, and anything else that should influence the judge in coming to a decision. And after careful consideration of all that, and after fully hearing both parties of a dispute, the judge can then render a decision. Now, justice is defined by Black's Law Dictionary as a fair application of the law. So to fairly apply the law, a judge needs to understand all the facts, arguments, and material. Now, in my case, in a specific decision I was appealing, I'm going to tell you some of the facts of the case and what I was trying to achieve in my motion. Now, I've been having problems process serving a defendant in this action. The defendant's name was Trina Rogers. Now, this defendant is a neighbor of mine, and I've had issues with this defendant for as long as I lived at the property. Since day one, it's been a problem, and it hasn't stopped. Now, what the motion was, is I was seeking the court to make an order that would order costs against Trina Rogers for her conduct, as well as make an order for substituted service. So from this point into the future, service would be considered done by just basically walking up to the front door of her residence, announcing what the document was, taping it to the door, and leaving. Seems pretty straightforward. The reason why I was asking for this order is because from the time of filing the action, which had the file number FC45.11, every time I tried to serve this defendant, she would conduct herself in such a fashion to try to avoid service. As in, if I knocked on the door, no one would answer the door. Even if I knew she was there, and I'd have to return several times until I actually saw her through the window, and then at which time I would announce I was leaving the document, leave the document at the door, and leave. Now, each time I did that, she would go ahead and call the Fredericton Police Force, and they would arrive soon after, running around all wide-eyed, looking for something. Me, if they found me. Now, I think it's inappropriate and outrageous that someone is going to call the police when they know who's at the door. I announced who I was. I announced my purpose was to serve court documents. I had them in my hand. All she had to do was announce she was accepting service, and I could leave them at the door and leave. Instead, she calls the police. Trina tells the police that I am at her door trying to serve court documents. Please send a car. Each time that happened, that put me in danger of being arrested and severely harmed by the Fredericton Police Force for whatever else her chimerical mind may have made up. This happened repeatedly, time after time. Now, I tried using other process servers who were unsuccessful at serving her, to the point where I even attended at a distance when these process servers were attempting to serve documents and observed, so there would be a second set of eyes to see that even though she was home, she was not answering the door. One of the times, the process server walked up, knocked on the door. It was apparent that she was home. And after knocking on the door, he came back to ask for further instruction. Between the time of coming back to ask for further instruction and getting back to the property, Trina Rogers ran out of the house, jumped in her car, and drove away. Nearly run over my process server in her speed to get down the driveway. So hiring other process servers did not work. I had tried mailing by registered mail, which is another form of service according to the rules of court, and the mailed documents were refused. I was even told by the attendant at the post office that Trina Rogers was aware of what it was because she had looked at the name of who had sent the package, and it was only after it was realized who was sending the package that the package was refused. So why would I continue wasting time and energy sending documents by registered mail when that service was frustrated as well? So I was receiving a lot of difficulties in trying to simply process serve documents. I was being put into danger by the Fredericton police being called every time I did that. And then, okay, so the regular ways of service, which were registered mail, did not work. Other process servers did not work. Myself, when I went to process serve documents, I had to return many times until I actually saw for sure that Trina Rogers was at the residence, and I would leave them for her. Now, this is unacceptable conduct in court proceedings. So I filed a motion requesting that Trina Rogers be basically reprimanded with costs for behaving in this way that's putting me in danger unnecessarily, refusing to pick up documents, refusing to accept service, and calling the police on me. So I wanted to, as a cure of that, a cure for that is to have substitute service from that point on, where all I had to do was walk up, knock on the door, announce what the package was, tape it to the door, and leave. Simple for everyone. Very good solution, I thought. What ended up happening was the judge actually ordered against me and did not grant my motion and the orders I was seeking. Did the opposite. Condemned me unfairly, claiming I should get a professional process server when I had already tried other alternative process servers and that had not worked. The judge had said that she wouldn't open the door for people she did not know either. But the fact is, Trina Rogers knew who I was, knew that I was serving documents, identified me, and actually identified me to the police when she called. So it's not as if she didn't know who I was. Now, this was a simple matter where it would have been a simple order just to order substitute service, order the cost. I had 3 affidavits in support of my motion. 2 independent individuals and myself who corroborated each other's testimony of certain key events that were stated in support of my motion. So that's 3 corroborated affidavits. The defendant provided only her own affidavit, which for the most part said nothing of value regarding the motion, and the parts that were valuable actually supported and corroborated my claims that she avoided picking up documents at the post office, and this is admitted by affidavit. She admitted to not picking up documents by registered mail at the post office that were from me. She knew what they were and refused them. She also admitted by affidavit that she knew who I was when I was serving documents, and instead of accepting documents, she called the police. So there's 4 affidavits, all in support of the relief I was seeking, which was simply an order for substitute service and cost to reprimand the bad behavior of the defendant. The judge instead ordered $500 cost against me and made many unsubstantiated and unjust comments at the hearing. Then further at the hearing refused to accept a post-hearing brief which is provided for the court that provided all the case law, all the common law, which is judges' decisions that supported my position that when litigants act like this, they should be reprimanded with cost sanctions. The detailed brief explained entirely my legal positioning, the relevant facts, and the supporting case law that supported my position. And I quoted Supreme Court cases which are binding precedent on the judge. Yet, despite all that, the judge ruled against me. I don't believe that decision is correct. Because of that, I've filed leave to appeal. The reason why I filed leave to appeal rather than appeal is because it's an interim motion. It's in the meantime between the beginning and the end of the litigation. So I'll keep you updated as far as the progress of that leave to appeal application. If you have any comments, please comment below. It's May 17, 2012. This is Justice Done Dirt Cheap. Just giving some information on some court progress updates. Thanks for watching.